Thank you, Abby. Thanks, everybody. I'm excited to be here with you today. Like Abby said, I'm BB Vanek, and I work at the University of Utah. I am hoping that we feel free to ask questions as we go along. I do have slides, probably more slides than I need, 41. I tried to cut it. I cut it from 73. So I did a pretty good job, but there's still 41 and we have about 45 minutes. So I'm going to give a pretty high level, it's going to be a high level conversation about what you need to do to design your privacy program. And I'm hoping that it is valuable to you. This is not intended to be legal advice. I am a lawyer, but I am not giving legal advice today. I'm also pushing my slides on here and on here so I can access my notes. So there's going to be a little bit of back and forth. As I said in the introduction, I'm hoping that you'll take away a couple of things. You'll understand the components of designing a successful privacy program. Really understand that every person in your organization is important and has a role to play in your privacy awareness at your organization and also in your privacy program. And privacy programs are not one size fits all. So this is designed to be a framework that you can think about how it works for your own organization. Breaches happen, and I think we probably have all experienced a breach either through a notification that your information has been accessed, or if you're already running a privacy program, breaches happen. They happen to good people, they happen to bad people, they just happen to people. Last year, over 22 billion records were inappropriately accessed in the United States. And like Abby said, I operated in the healthcare sphere, so I'm going to be talking a lot about protected health information, and which is why I included this information about reportable breaches that involved PHI or protected health information. It's almost 50 million Americans' protected health information was inappropriately accessed or disclosed last year alone. So I recently moved to Washington State, and I do a lot of biking up there. I actually work remotely for the University of Utah. And we have trails all throughout our little tiny small town. And so I do a lot of biking and I think a lot about biking. So I thought, what a perfect analogy for designing a privacy program. This quote by Susan B. Anthony: "The bicycle has done more for the emancipation of women than anything else in the world." Impactful, right? I'm just going to change it a tiny bit. "The privacy program has done more for the emancipation of regulated entities than anything else in the world." And I think this is really true. If you put some thought into designing a successful privacy program, you are going to be free in your business to operate your business, think about other things, knowing that you've already put in the work ahead of time. So be prepared for some really cheesy bike analogies throughout this whole thing. That's the hook. A note on the complexity of the global privacy legal landscape. So as I'm sure many of you are aware, if you're tracking privacy laws nationally and internationally, this is a changing landscape. Privacy laws seem to just pop up. And if you're getting notified of these, there are lots of new regulations that you have to keep in mind of. Approaches for these laws differ based on the type of data that's collected, the location of where your data is being collected from or your data subjects, also where the data is being processed. It can differ on the industry. There's, in the United States, state-specific laws. There are other types of regulations that are based on the sector that you're in. So the lens for today, as I mentioned, is going to be a law called HIPAA, so that operates in the healthcare industry. I think one really important note about privacy laws, and we'll go through this a little bit in a few slides. As you're evaluating what laws you would apply to your business and that you need to think about for designing your program, think about the most restrictive law and implement that as the floor and not the ceiling. And I think that you will be set. You'll be made in the shade with tracking these laws. why am I using this lens? One, because it's what I do. I work in this industry in privacy compliance in a regulated entity, and we're subject to federal regulation called the Health Information Portability and Accountability Act 96, and then further regulations that were implemented after that. A lot of people have heard of HIPAA. I'm assuming most of you have heard of HIPAA at least. A lot of people don't really know how it works or when it applies, but I think that's true of really sector-specific and industry-specific laws that impact privacy. But for our purposes today, all you really need to know is this applies to a defined term, a covered entity. So that can be, for us, it's a hospital, health plan. With other privacy laws, you're going to have other regulated entities potentially, and that's going to be defined by that law. And HIPAA is a limited sectoral privacy law, so it applies to specific types of data processed and held by specific industries. But as I was preparing for this presentation, and I also track privacy laws internationally and nationally, there are a lot of similarities with HIPAA and robust privacy laws that are being implemented or discussed and considered. And the terms of art, so things that we defined and they mean something really specific when you're talking about a specific law, I put here in parentheses. But the similarities of the purpose, increasing trust, ensuring that the data subject rights have access to their information, that the information is correct. Also to give the processor, so a covered entity, expectations on how they can process your information. Data minimization, which is what would be known as minimum necessary within HIPAA. So only using as much data that you need and nothing more. Transparency, so letting your data subjects know what they can expect as it would, how their data is being used and how they can access it. And also breach notification and portability of data. All of these are, they're appearing in privacy laws that are robust in the GDPR and California's laws, and they existed in HIPAA as well. So a final note before we dive into the framework is you don't want to,
If an organization is a HIPAA covered entity, can they ignore all other privacy laws in every way, or is there some stuff that falls under other laws?
Oh yeah. No to the first question. You never want to ignore privacy laws that might impact your industry, even if you're meeting the expectations of another regulation. And then yes, there would be some overlap. So I think that's, like I said initially, and it's important to repeat, that if you have created a program where your floor is high enough to the most, you can say restrictive privacy law, but it actually is the most protective law to the data subject, then you're going to very easily be able to implement changes as they occur and meet the obligations of other laws. Great question. So as we go through this framework, the goal is freedom. It's emancipation for your business, for being able to think about other things, because we know breaches happen. And you want to trust your privacy program that they have you covered, essentially. And that's why I think what's important as being a privacy professional is you want people within your organization to come to you when they know that you're the subject matter expert, and you want to be able to quickly adapt to changing regulations. So you don't want to reinvent the wheel every time a new regulation passes. If you have systematized your privacy program, it's quite easy. I shouldn't say easy because it's not easy, but it's streamlined and it's more simple to manage implementation of a new regulation. Today, I'm talking about, I'm giving you 7 different points to think about when creating your privacy program, and each coincidentally will be a piece to build a bicycle, because why not? And but the frames that I'll be relying on are frames that the University of Utah relies on to implement our privacy programs, the U.S. Sentencing Commission's 7 Elements for a Successful Privacy and Ethics program. And then I'm also taking some inspiration from the International Association of Privacy Professionals. If anyone has heard of that organization, they have a program for privacy management. And so I'm sprinkling in some facts from that as well. So the first element we have here is your framework. You're taking your bike frame here and you're creating your privacy vision, scope, and your strategy. So the first thing to think about is not having a privacy vision and mission statement that does not align with the goals of your business. If you had, a very robust and well-intentioned privacy mission statement that just is not compatible with what your business does or can do, you're setting yourself up to fail because you're saying you're going to do one thing and that's your intention, but you're going to be banging your head against a wall trying to make it work. You also need, when you're thinking about creating your privacy vision, so an internal statement to scope out your privacy program and writing a privacy mission statement, think about the laws and regulations that your entity or your business is actually subject to. Identify stakeholders and internal partnerships. And this is important just throughout along the way. If you identify first who might need to be brought in at the start, let folks know that this is important, that privacy is important and why and how to measure that, and that you'll be the person that's going to come to them and explain, hey, we have a breach. You already know what we're going to do. Here's your role. You want to identify who these people are initially. And so it's not a big surprise when you come knocking on their door and say, oh, I have a ton of policies we actually need to implement and we need to communicate to our employees. And it's really important. If you have those conversations before, they know you, they trust you, and you can implement those policies a lot easier. And then the final piece of this is drafting those policies and then later communicating them. But drafting your policies after you take into consideration what your scope is, what your mission statement is, your purpose, is drafting policies. So a little bit more, and it's a little redundant, I realize now. I could have just deleted the slide, but a little bit more on your vision and mission statement. You want to be fully aware through data mapping, if possible, at least an inventory of your data, what data you are collecting. And that can change when you develop new business lines or service lines, or maybe your business changes. So your vision and your mission statement and even your privacy policies are living documents. They can be flexible if something changes, especially if you are familiar enough with what the business is doing because you've developed those relationships with C-suite, with legal, with sales management. You know the direction you're going, and these can be addressed and these changes can be made before you find yourself in a tricky situation. It's important to track the relevant laws. We've already talked about that, but that's important. Find a way to do that either by following listservs that are providing updates on regulations that you might be subject to. Another important aspect is understanding the penalties for non-compliance with those regulations, and then you can scope your privacy policies accordingly. And it's important to communicate the policies too. But that comes at a different slide. So your strategy, and I stated at the beginning, but I think it's important to reiterate that everyone in your organization is important and plays a role. You want to have privacy be embedded as an expectation. It should be included at a lot of different areas, training, which we'll talk about, onboarding, and also just have a general expectation that privacy is important. I did put an exclamation point, the only one I used in this presentation, on policies, because I think that's really important. You want to memorialize the work that you've done so you can rely on policies both for issues of noncompliance and then also showing your good faith effort to meet the expectations of the laws that your business is subject to. So I'm going to give just a tiny example of when element 1 goes wrong. So This was a very recent breach incident. Yakima Valley Hospital was a hospital actually in Washington State. They had a breach of almost, 419 patients. So in the scheme of things, not a lot of people. But what happened here is Yakima Valley did not have privacy policies. They didn't limit access to their medical record. So security guards who were contractors, so third party vendor had been brought in to provide security guards, were able to use their access information to look in the medical record and snoop at patients that they were checking into the emergency room. Not a good thing. These folks should not have had access to this information. There was no business need for them to have access. And really what it came down to is there were insufficient policies in place, access, especially related to access. So the strategy and the scoping for a privacy program did not capture that this was a risk. And they were, this hospital was fined only about $250,000, but reputationally, I mean, this is hard to recover from. Luckily, it was under a notification level that it didn't have to be, publicized in the newspaper, which is what HIPAA requires at 500. But I mean, it has been on my radar, maybe because I'm in this sphere, but I'd be curious if others had heard of it. Moving next to the next part of your bike, the steering handlebars, steering. To steer your privacy program, I want to say steering wheel, but I know it doesn't exactly fit, but you get what I'm trying to do here. So who's going to steer your privacy program in the direction? So you've done all the work, you've created the policies, you have a vision, you're ready to go, but who steers it? So you should pick a person, a privacy officer, oversight compliance group, or a privacy group that has delegated authority, but to help steer the direction of your privacy program. That person should have autonomy, responsibility, and authority to actually do something. This shouldn't just be, a token. This should actually, in order for your privacy policy to be, or your privacy program to be successful, this person needs to be able to do something. And I consider governance models because I think this is really going to be one of those places that your privacy program has to fit the way your business works. So the University of Utah is centralized, but a lot of industries are either decentralized with, businesses in different countries where they're collecting data from different, not businesses, but offices in different countries, service lines that do very distinct things. Decentralized, and then some have a little bit of both. So you need to think what works best for you and how you'll be able to get information out when you're trying to designate who or how many people should fit this position. So privacy officer and the privacy office, really you want this to be publicized, and under a lot of the new more robust privacy laws, for example, the GDPR, there are requirements and HIPAA that this information is available to your data subjects. Who your privacy officer is in the GDPR, that's considered the data protection officer, though that only applies if you're doing certain data processing, and we can't get into all of those nuances. But there's a requirement to keep this person trained, to provide them access to your C-suite so that they can actually have a role. So they're not just a token. So I think that's important to keep in mind. And then again, with governance models and your organizational structure, think about where this person or this office should live, and how to post information about them so that you can get that to your data subjects. And then separate but related is an oversight committee. And this, I think, is also very important. So your privacy officer, sure, could unilaterally make decisions about data use, but it also helps to bring in folks with expertise at certain times when you have big questions and big issues about how are we going to use data? Are we doing this correctly? Can we approve de-identified information, which, which is important in our world? Can we de-identify information that we have, and what can we do with it that we're not violating the trust of people who give us that information? So an oversight committee is a good thing to have to centralize decisions. It's important to track this. So make sure that if you create a data governance or an oversight committee, you are keeping notes, you're recording their decisions, and that you're being consistent. And these people, again, should be trained ongoing. So a couple slides ago, talked about a privacy roadshow. And for some people like me, privacy is really interesting. I really like it. For other people, it's really boring. And they're like, I don't care. I just want to do my job. And so a roadshow can sort of give you an opportunity to meet people. They can ask you questions. You can champion privacy in a more informal setting and help people understand what their roles are. So when element 2 goes wrong, so Dr. Northcutt was a dentist. He might still be a dentist, but after this might not be. He had a lot of patients, but he also had political aspirations. And he talked, and this is not no to being political. This is just no to using your data subjects information to be political. So what Dr. Northcutt did is he used his patient information and he sent out thousands of letters to his patients talking about his political aspirations. They didn't need to know, or they didn't maybe want to know. Some of them didn't, but either way, this was against the law. So he used their data in a way that wasn't, they didn't plan on it, they didn't approve, and he also passed their name, contact information, other sensitive information to a third-party campaign manager and marketing vendor to send out these disclosures. So the problem here is he didn't have a privacy officer. Not that the privacy officer is a silver bullet, though the University of Utah privacy officer is here, actually. And she can be a silver bullet in important times. But he didn't have a privacy officer. And I think if he had, they would have said, ooh, I don't think so. Let's find a different way to go about this. That's the benefit of a privacy officer and your privacy office. If folks know how to reach you, you can say, this is a really bad idea. I don't think you should do it before it happens, instead of, oh gosh, this happened. We have to report this breach. So he was fined only don't know why I say only $62,000, but maybe because some of these fines I'm seeing now, like with Meta, are in the millions. I mean, these fines are sort of small pennies when it comes to some of these big data breaches. But I digress. So, yeah.
See, when somebody or something it's a fine.
Mm-hmm. Yeah.
Is it gravity?
Yeah, great question. So it depends on the regulation. In the case of a HIPAA settlement agreement, which most of these that I'm using as examples were enforcement actions that the parties then settled, so they didn't fully, go to court. That money is typically earmarked for the victims of the data breach. I can't speak to the GDPR just because I'm not an expert quite yet on that, but I do know that some money is typically earmarked for victims of the data incident, for credit monitoring or whatever had happened to them because of it. They don't typically get, like us, you class action, you get $10 because this happened to you. But the money also goes to the entity that's regulating. So the Office for Civil Rights regulates in the HIPAA industry, in HIPAA, the HIPAA world. And so they get that money to do more investigations. I would say, though, to answer your last question, is this money a remediation? Essentially, does that money go back? Not that you said go back, but the money does not help the entity that experienced a breach. It doesn't help the covered entity. It's a slap on the wrist to them. They don't see it again, but these are corrective. The settlement agreements define the corrective action that the entity needs to take. And so that corrects the problem for the future. And then the Office for Civil Rights is really public about these if you're in this industry. And so it's sort of like looking at the naughty list, what people are doing wrong. And then you can say, oh, we need to maybe check and see if we're doing that, because it's public and you can maybe learn from someone else's bad mistake. The third element here is your bell, communication and education. And this is internal and external. So those policies I used the one single exclamation point on, really important. You want to communicate those. So you have to have effective and ongoing communication of your policies, of the expectations of your employees. We have multiple different avenues to train at the University of Utah. We have required trainings that occur annually, and I think we do a pretty good job. So annual trainings that we're tracking, we know that an employee saw this. We can rely on that training, that if there's a breach and an employee was at fault, and we can say, oh, did they do that training? That helps in the assessment of what a discipline might be. But we also have smaller settings, which we call HIPAA champion meetings, where we're championing this information, and we're giving condensed small takeaways, lunch and learns. I mean, it goes by a lot of different names depending on what your industry is, but think about different ways to be effective with the training you're communicating. Because breaches happen, I think it's very important to leverage those privacy incidents, learn from them, improve, and then also use them as training. These are growth moments. Otherwise, why are they happening to us? So you really have to think about what you can learn from those and how to say, look, we did this. This wasn't great. How can we do it differently next time? And then external, you're needing to communicate with your data subjects as well. And that happens through your privacy statement, through your policies, whether those are posted internal or external. You communicate your commitment to your data subjects and how you respond to their data subject requests as well. So just a little bit more about internal communications. It's important to measure these. Like I said, we track, but also you can measure the effectiveness of information that you sent out. For example, if you have a phishing awareness campaign and you've put information in your elevators, in your intranet channels, you put information, however else you give that information out to employees, you can see whether or not it's effective by if your employees are clicking on phishing emails. You can send those tests out. So using those metrics help to justify the training that you're doing, and then also you can use that in response to an inquiry from a regulator and say, look, we're training, we've been tracking this, we know that we hit this on this date. All of this goes into your program being successful. And external communication is equally important. The, publicly posted mission statements for a privacy office are important. You want folks to know what your commitment is to your data subjects. I mean, we're all basically in an industry, I'm assuming, but I think this is correct. Everyone relies on a customer, whether that's another business, whether that's a person using your service, whether we're a hospital, it's a patient. We rely on a customer or a person coming back to our business. And so it's important to be really transparent and not make promises you can't keep, but also be truthful. What are you doing with the data? Because if you're lying, that's another but bigger problem. And record keeping shows up a lot on my slides. I think it's important just to track your work. What are you doing? What communications have you had in the past? How are you changing those? And communicate, especially with HIPAA, it's very important. GDPR, California's laws are very important. Responses to data subject requests, even if you're denying those, keep a record of why you're denying those and make sure it's consistently applied. Because then you get into a whole other can of worms with discrimination, and we responded to one in a certain way and another a different way. So you want to make sure that this is transparent, it's uniform, and your responses are timely. And those certain regulations have timelines that are required. So here's another. Oh, yeah. Yeah.
So I am on the Observepoint side.
Okay.
I work with a lot of our new customers, and we hear,
Fairly often where people have experiences,
especially I work with the financial services industry.
we find a lot that they're accidentally collecting PII in a form or something in their analytics.
Yeah.
And so a lot of times they're
Question, they voice that to us. Obviously, we can.
Legal advice.
Their question is, okay, we stop. We were able to correct what we were doing. We stopped collecting in our analytics. But like, what's the next step internally? And then obviously you kind of talked about the internal and external communication. But what do you recommend when someone realizes that it's not public, but maybe their specific team?
Yeah, that's a really, really great question. So if folks didn't hear, the question is basically if you accidentally are collecting more information than you planned or that you gave notice about, what are your steps after stopping that? And I think that is really specific to the regulations you're subject to, the industry you're in, financial, payment card industry, there's a whole sector regulations on that. And so I would say your first step is talking to your legal counsel and making a decision there. And we'll talk a little bit more about enforcement and breach responses. But if you have an incident that might be a breach, because what you're describing could potentially be a breach, you're collecting information you did not notify folks about, you're holding on to it, you want to talk to legal counsel so you create legal privilege and then get direction. They'll do the analysis of what you should do next. But I would say you probably don't want those people who this issue happened to just go about and like start doing whatever, like, oh, we have this data, let's just do something with it. Definitely don't do anything with it. Stop what you're doing, correct the issue, and then find out what your next step is, whether that's could be notifying the folks whose data you collected, could be notifying a regulatory body that they're subject to. But I think the first step is just talking to legal counsel and finding out. Yeah, good question. So element 3, when element 3 goes wrong, this one is like, this happens more. There were multiple examples of this that I could have used, but it like shocked me so much this occurred. So Manassa Health Center is a psychiatric facility. I should have checked if these were still active, but I didn't. I just assumed. So I'm talking in present tense. This is a psychiatric healthcare facility that received some really negative customer reviews, patient reviews online. And Manassa responded to these reviews by disclosing patient information in the body of their response. So it was, for example, hey, I didn't like my doctor. And then the doctor wrote back, hey, I didn't like you. And I didn't like that I had to treat you for your childhood trauma related to yada, yada. Like they put in some very specific patient information. And right, like you're shaking your head because this shouldn't happen. We know enough about HIPAA as lay people that my protected health information or my sensitive data, my credit card information shouldn't be included in a review that I leave on a company's website. So, and I'm condensing this down to say that the problem was only that they didn't have training or awareness or about the privacy rule and how to comply. And there were other issues there, certainly. But if they had training and awareness about privacy, and privacy was something that they were championing in this clinic, this probably wouldn't have happened. They would have had knowledge on how to respond to these patient complaints. So the next element, we're almost done. We have 7, so we're over halfway there. The next is your gears. So internal auditing and monitoring, and I'm lumping in with this as well, risk assessment, which is sort of like auditing, but it's a defined term for a lot of regulations. So we're just gonna put it here for ease and brevity. But your gears are what makes your program run. It also helps to normalize privacy within your organization. So use internal tools and existing tools. If you already have a group that audits at your organization, you can rely on their expertise. So again, you're not reinventing the wheel. You're not creating something. You can use them for certain audits to evaluate both the privacy program itself and then also the implementation of your strategy. You can also, for risk assessments, what's critical there is figuring out the vulnerabilities in your entity. So that's separate from auditing and evaluating the success of the privacy program, but it's similar, and it's required by a lot of these robust privacy laws that you need to be conducting regular assessments of the vulnerabilities with access to data and record keeping about what you've done. Inventories and risk assessments. So again, as we talked about in element 1, your frame, you already did this inventory. So what's cool about a privacy program, if you're building it from the ground up or you're improving one that already exists, is you do a lot of this work in the beginning, and then you can rely upon that work, and it reappears as your privacy program matures. So you've done that data assessment already, but it's an ongoing thing. Maybe you have a new service line and you're collecting new data. You want to log that. You want to track how data is being accessed. This needs to be regular. It's not a one and done thing. You can't say, oh, well, we did a risk assessment in, 2 years ago. We're probably still good. No, because you're not. You're just not, for many reasons. You want this to be persistent. I liked that. Consistent, persistent, and layered. So you can't just do one risk assessment to one arm of your business. This needs to be anywhere where data might be vulnerable. That's employees bringing their personal devices. That's your IT systems. So you want to think about where might data be accessed and find out where it's vulnerable. And we could go into, I'll just say briefly on audits, conducting audits. If anyone's been an investigator before, or they conduct investigations at your organization now, it's important to do work before you conduct your audit. So have an audit schedule, have a plan for where you're starting, where you're going, and I think it makes sense to build that schedule based on risk. What's most risky? Where do you need to make changes immediately? Have a plan before. So before your audit, do preparation, talk to people that need to know. Oftentimes, this doesn't need to be like a surprise, we're auditing you. Sometimes it might be, but I think if you bring in and collaborate with the groups that you're auditing, you're going to give people information to help you conduct your audit. Though if it needs to be a surprise, also fine to just surprise, we're auditing you. But you should have a plan, know who you need to talk to, do a lot of preparation so you aren't drawing this out for months. Conduct your audit, and then post-audit's equally important. You need to create a report, deliver that to who needs to know, and then actually follow up on the risks and vulnerabilities that you identified. So a time when audits went wrong and risk assessments went wrong. Here you have Exelis. My notes on this one, you guys. Exelis Health Plans is not excellent at risk assessments. That's what I wrote. But it's true. So they were not conducting ongoing risk assessments, and they paid the price. So they experienced a cyber attack, and it was like 10 million patients. The information were accessed by this. And the previous slide explained that Exelis Group included a bunch of different covered entities. So insurance plans, healthcare providers in a couple of states in the Northeast. And they just had no idea what their vulnerabilities were. They weren't auditing privacy incidents. And so they got slammed with a $5.1 million settlement amount. So the highest we've seen so far that we've talked about today. And it really came down to not conducting risk assessments of where their vulnerabilities were, because it's both the risk assessment and then it's fixing those vulnerabilities. So they had to make some major changes there. Our fifth element, the petals. So your reporting and investigating is a critical aspect of the success of your privacy program. You want to make employees feel that it's part of their job to report incidents, that they're, I don't want to say that they're in a protected environment if they report that they did something wrong, because sometimes you have to provide corrective action to an employee who has maybe a history of clicking on the phishing email. You start small, but you do want to encourage people to self-report. Take that into consideration when you're evaluating. And number 6 is, I think number 6 is discipline, but you want to encourage people to feel safe reporting, and you want to ensure that you have thought about what an investigation is going to look like, what resources your privacy program needs for that investigation before you have to conduct an investigation. You don't want the first time you're thinking about, well, what do I need to do, be when someone says, oh gosh, well, we've been hacked and like 10 million Exilist. You don't want to be Exilist. We've been hacked and there are 10 million patient reports that this cyber group has. You want to know what you need to do to investigate how that incident occurred. And I think one really important piece to keep in mind if you contract with third parties, you have vendors that you use, is requiring terms in your contracts with third parties about how they will respond to an incident. Whether you'll do the investigation, they'll do the investigation, will you collaborate, understand the rules, require that they notify you if there's an incident and within certain timeframes. And also consistency. I think we've seen that a lot in developing your privacy program, is being consistent in how you're responding to reports and how you're investigating. Another thing we're seeing again, leverage privacy incidents. These are teaching moments. So when you're doing training, for example, back in the communication slide, which I now can't remember, the bell. When you're doing you're communicating, you want to clarify the roles of each individual and conduct tabletop exercises. And we could spend a whole day talking about breach response. So I'm just going to briefly say that you want to have relationships before with the people that are going to be at the table and practice what each person's response is. And again, be aware of what your reporting and record keeping requirements are in the industry that you're in and the laws that you're subject to. Centara. What happened to Centara? Oh, okay. I remember Centara. So Centara is a hospital that knew it had a problem. There was a breach, but it looked at the privacy rule. Centara, maybe they're legal, I don't know. Centara looked at the privacy rule and was like, I don't think this breach is reportable. So in the privacy rule and the HIPAA rule and in other privacy regulations, there are sometimes definitions that help you evaluate whether a breach is reportable. And in the privacy rule, certain criteria has to be met that make it reportable. Centara said, we don't think so. OCR investigated them and said, it is. Can you please officially report to us? And they were like, no, we're good. We're not going to report. We don't think it is. And OCR repeatedly said, the Office for Civil Rights, which is the enforcement arm of the government that regulates covered entities, they repeatedly said, you guys have to report. And they said, no, we're good. But they eventually reported. And then they miscalculated the number. They just had problems. They miscalculated the number of patients who were impacted. And then finally, they didn't require in their third-party contracts with their vendors to report to them if there were privacy incidents. So they had a lot of problems all related to reporting. Yeah. Yes.
Let's me about police guys. Did you get on the list?
Yeah, the fines are just a small part of this. So the question was, can I speak a little bit more about what happens in these incidents when there's a breach, and with OCR specifically, their corrective action plans. So this, in a lot of regulated entities, the laws that the entities are subject to, so in Title IX as well, which is sexual harassment and gender harassment when you receive federal funds, there's an opportunity, if you've been investigated by the federal government, to agree to be better, basically. To say, like, we know we have a problem, but we're not admitting guilt, that we've done anything wrong, and you release us from liability, but we promise that we're going to do X, Y, and Z, usually and hopefully directly related to what caused the incident in the first place. But sometimes, as you could probably assume, when you look under the hood of a car, there are other problems. And so these corrective action plans are often really extensive. So I don't really get a lot into it other than mentioning what the settlement amount was and that they're required to specifically fix the issues that they found out. But they're also agreeing to long-term review and being tracked by these regulatory bodies to make sure that they're doing okay. And I'm certain that if they don't, and it's in the contracts as well, the settlement agreements, that if the entity is not making these changes or if they have additional breaches, the settlement goes out the window and you could basically be back where you started. So it's really important, obviously, to have legal involved. And I'm not just saying that because I'm a lawyer, but to have legal involved at at every step along the way, and evaluating your settlement requirements for these corrective action plans. Let's see. So second to last, and I think I'm okay on time, 45. Okay. Is your seat. So honestly, at this point, I was just sort of grasping for something to fit the bike analogies. I don't really know. I think I have my notes here say, you'll be in the hot seat as a privacy professional. So I tried to make some connection to keep this lively because, like I said, I know that this is not everybody's day in, day out, but you're here because you have some interest in privacy or implementing a privacy program, and I thank you for that. But enforcement and discipline, so this is internal for the most part. So you want to establish incentives for compliance. Make it easy for your employees and for your organization to comply with your privacy policies. And then through that compliance, you're complying with the regulations that you're subject to. Really think about privacy by design. I think that's sort of a hot phrase these days for folks in the privacy industry. And it's easier said than done when you already have an established business. But moving it forward, it basically means building in privacy at everything that you're doing. So if you're developing new software, you're developing an app, you're developing a new service line, think from the start how to make privacy a part of that and have it be accessible. So I'm sure folks have heard the phrase dark patterns. It basically consents that really you're not consenting to as a consumer. You have to, your Tesla, if anyone has a Tesla, which I love those cars, they're beautiful. But in order to drive your Tesla, you're basically saying, I consent to you collecting all of this data about me. And so is that really giving you a choice to say, no, thanks, don't collect my data? Not really, because you're getting the benefit of driving the car. Anyway, I digress. But you want to think about enforcement of your privacy program at every level. And then really important, and I've mentioned this before, consistent discipline or corrective actions for violations that occur. You don't want to... And governance models we talked about before makes this a lot easier. If you have a centralized governance model and one body who's doing these investigations, they can be sure that these are consistent, their enforcement actions are consistent, and corrective action is consistent. I also think it's really important to have clear expectations of what a person could expect if they were involved in a privacy incident. And that can be delivered through training. Also just being available as a privacy office to answer questions at any level of the organization. Those privacy roadshows I also think are pretty great. You can talk about, hey, we've seen an uptick in this type of incident, phishing. I myself fell for a phishing attempt, and I hate to even admit it because I'm like, oh, privacy, it's everything. But I fell for a phishing attempt. And then our training specialist in my office was like, hey, sorry that happened to you, but you're going to need to present on it at our next champion meeting. I was like, really? I have to tell everybody about falling for a phishing attempt? And yeah, I did. And I think it helps because, no, we're just human. Everybody's thing. And these these malicious actors are getting really sophisticated. This one wasn't that sophisticated, but it was late at night and I shouldn't have been on my phone. So I blame myself mostly, but they are getting really sophisticated. And so, anyway, have clear expectations about what's going to happen and understand your obligations and timeline for notification, both notifying folks that data was impacted and also regulatory bodies. But again, all of this just comes back around to thinking through from start to finish what's going to be expected of your privacy program, and then putting that in writing in your policies, having clear standard operating procedures that you can rely upon when this day happens, which it will. And that's why you have a privacy program. And then professional memberships for reality check. I don't know that this applies with every organization, but I have found a lot of value in the professional organizations that I'm a part of, where there can be either anonymous or private conversations about, hey, what are you guys doing? Like, we're all subject to the same regulations. How would you handle this hypothetical if this happened to your organization? And then it's not just you in a vacuum, but you're talking with other folks who are grappling with these hard decisions and who are experts in their field. Like, rely on others, because there are memberships, there are groups that you can join and have these conversations. So when your seat doesn't fit, no, I don't know what I was going to say there. But here's an example of a breach related to enforcement and reporting. So Athens Orthopedic Clinic experienced a hacking incident, and they themselves didn't even identify it. So unfortunately, I wrote that and I was like, shocking. But I actually think that probably happens. It's probably more than we think, that someone's like, oh, that's my private health information. Why is it here? And then they contact your office, or it's their sensitive information. They contact your office and you're like, oh, goodness, we experienced a hacking incident. But hey, if you encourage people to report and you have a culture of compliance, that is okay. That's welcome. Like, we want to know about it so we can stop the bleed. But here they experienced a hacking incident and their response lagged. They didn't have any policies. They didn't have any plan for what to do on how to, one, identify where this issue is coming from, so stop it. And that's working with partnerships, IT, information security, HR, potentially. I mean, you want to know the people that you should go to when it's outside of your realm. So those relationships are really important. Here, their response lagged. They didn't have any policies or training on what to do when they experienced a breach. And then again, their vendor contracts didn't require their vendors to report to them if there was a breach incident. So on this one, I didn't write down how much they paid. Oh, I did. $500,000 is how much they had to pay. And they had to update and correct these incidents that caused the problem. So finally, your wheels, your response and prevention. And I think I said something cheesy like, now you've built your bike, now take a ride. But I don't think and now I've said it. So wheels, response and prevention. So you have done a lot of work creating your privacy program. But as we know, breaches happen. So you want to take some significant time planning a breach incident plan or your breach response plan. You want to resolve problems promptly. So you want people to know who to contact when a breach occurs. You don't want that sitting in an inbox, which happens. When you get a notification, it can sit in someone's inbox if they don't know what they're supposed to do. We all know, how many unread emails are you guys going to return to when you go back to the office? Probably 100 more. So people need to know how to respond when an incident occurs, if they receive information about it. And I think I put reasonableness there because a response is going to look different depending on your industry and depending on what you can do and you have funding to do and the nature of really everything that the data involved. So work with your legal counsel to determine what a reasonable response is under the circumstances. And then again, ongoing monitoring and record keeping. I think it's really important, if you take anything away from when you're thinking about creating your breach incident response plan, is understanding the roles of stakeholders, legal privilege is really, really critical. So if you're lucky enough to have in-house counsel or outside counsel, you need to evaluate how to ensure that your conversations about the breach before you've determined what the whole expanse is and what you need to do are covered by legal privilege. So sometimes that looks like having a conversation with legal, and then legal sends you an email that says, hey, start this investigation. So everything flowing from there can be covered by that legal privilege. Really think about business continuity plan. So this really comes down to, say you have like a disaster and you need disaster recovery. You have a ransomware attack. You need a business continuity plan. And I guess even in a smaller case, you need to know how to keep your business arm running while you're investigating and you're responding to a breach that occurs. Think about the insurance you need to carry, what notifications are required, and then how are you going to recover? And under recovery, these are teaching moments again. Like, they're going to happen at some point to you. They're going to happen again or at some point to us. Like, they just happen. And so how can you grow after you have fully gotten through your breach response? You've notified as legally necessary. You've done what you've needed to do pursuant to the laws you're subject to. Think about that recovery. Because I've talked about breaches throughout this whole time, I thought I would end with an example of an initiative that the Office for Civil Rights started called the Right of Access Initiative. So HIPAA, like a lot of other privacy laws, gives an expectation to the data subject that they can access their health information. And this was launched in 2019 in response to a concern that patients were being denied access for a long time or sometimes forever to health information that they should have. Some responses are like, I sent a request to my healthcare provider, never heard back, or heard back a year later, 2 years later, never got my health information. So these are occurring more often than you think. And there have been more than 40 enforcement actions since 2019. And why I think that this is relevant is because when you get notified of a new hot enforcement action in your regulated industry or in whatever industry you're in, you need to be able to check quickly whether or not you are compliant in this area, and then you need to be able to respond if you're not. So I think the value of planning a privacy program in the way that I have described, at least framed out for you, is you can do this effectively and quickly because your frame is already there. You already have your bicycle, so you can just get on and ride through the new regulation, implement everything you need to do, and you're going to be sure to be compliant with hopefully all laws that come your way. So I hope that this information's been helpful for you and that you either can improve, build. Maybe your privacy program is just great as it is, and you find freedom in having that privacy program. Don't let perfect be the enemy of the good. So make any efforts to correct issues and risks and vulnerabilities as you see them. It doesn't have to be perfect. Breaches happen, and everyone has a role to play. Thank you very much, you guys. I appreciate your time.